Welcome to today's show. My name is Glenn Diesen. I'm a professor at the University of Southeastern Norway. With me is the great Alexander of the Duran. And the guest today is Rein Mu. I hope I pronounced it correctly. Sorry. Anyways, I would just like to take a very quick, take a minute to explain your extensive background, as it's quite relevant to the discussion, because you worked with the Soviet leadership, or more specifically, you were the legal advisor of Gorbachev, and thereafter you were the deputy foreign minister of Estonia, and prior to that you were also on the UN Human Rights Committee. So what I find interesting is, as we once discussed, you wrote the draft declaration for Estonia's independence, and you wrote also Yeltsin's text recognizing Estonia's independence. So I thought it was interesting having a foot in both camps there. But yeah, you've also been a professor at the London School of Economics, King's College. You were the rector at one of the universities in Estonia. You were also the president of the law school in Tallinn. So, and extending upon the list, you also have 14 books on international law, which is the topic of today, and more than 300 articles, which is makes up a solid amount of scholarship. So, anyways, I first met you in Kazakhstan in 2018. We were both on the Astana Economic Forum. We were on a panel together with Franco Fion and Vladimir Yakunin. And I find your background in international law fascinating, especially due to your own also personal background, both from Soviet politics, Estonian politics, and as a British professor then. So I always thought this results in some very insightful perspectives. And that's definitely something we need these days, as we're always forced to choose camps and define who are the goodies and baddies, which tends to be a dumbed down version of discourse. Anyways, I thought we can just jump into it. And the topic of today is really international law, as this is where you are an expert. So maybe I thought we could start with a bit wide question. That is, how has international law really changed the way you see it over the past 30 years? What have been the advancements or the challenges?
30 years ago, of course, there were great expectations about the rule of law in the world, and I wrote not only articles and in my books, but also in speeches for President Gorbachev, for example, about the primacy of law over politics in international relations. So we expected something completely new relative to the Cold War period of international law. So, and there were developments, let's say, which I considered, and many considered, positive at the end of the 1980s, at the beginning of the 1990s. And you mentioned my background as a member of the UN Human Rights Committee, for example, in Moscow. How I became a member of the committee was that I advocated ratifying by the Soviet Union certain human rights, UN human rights treaties, and many were against. But Gorbachev and Edward Shevardnadze, who was then the foreign minister of the Soviet Union, they agreed, and so my ideas were welcomed, and I was proposed to become a member of the UN Human Rights Committee from the Soviet Union then also. So this was quite positive. But now what happened already in the 1990s probably was that there was too much enthusiasm, probably quite naive, and certain developments led to And first of all, I have to say that, of course, it was not that law or attitude towards law changed much, but the situation in the world changed considerably, and therefore, of course, this had an impact on international law too. And it was that, in my opinion, now with hindsight, of course, not then that I had this view, that instead of international law, which is based on balance of power, or has been always based on balance of power, there started emerging elements of which I would call now world law. So international, without any balance, because there was no balance of power then, and not even foreseeable. There was one center of power, really. This was the United States. And the development of, for example, of international criminal law, international criminal jurisdiction, wide use of force, allegedly mostly for humanitarian concerns, and interference in internal affairs, also with, let's say, positive aims usually. But this was all that one part of international law, which one famous American professor, Wolfgang Friedman, called international law of coexistence, was forgotten, and this international law of cooperation or international law of integration, which was also promoted by Wolfgang Friedman, this emerged. And the basis of international law, this international law of coexistence, with its principles of sovereign equality of states, non-interference in internal affairs, non-use of force. This part of international law was considered as outdated. Now, and also, of course, though it may be a minor thing, in London, when I started after my 1 year in the foreign minister of Estonia, I was invited to the London School of Economics, and suddenly there was nobody to teach international criminal law. And I had written a small article once years ago, and therefore I was asked to teach it. I had 10 students, master's degree students. And then with the creation of the Yugoslav Tribunal, Rwanda Tribunal, I had hundreds and hundreds of students who wanted to study this. But I was very skeptical, because in international relations, which are political in substance, there is not so much place for criminal law. Therefore, I stopped soon. When I moved to King's College as professor, I stopped teaching international criminal law. But this is what this enthusiasm about international criminal law, that all human rights are universal and they should be the same in Europe, in Iraq, in Afghanistan, and so on. This seemed a bit too much for me even then. And this is how international law, in my opinion, became undermined. Instead of, let's say, building on this, what was existed before. Because there was, during the Cold War even, there was this balance of power. The arrogance of one superpower was balanced by the arrogance of the other superpower, or superpowers, their coalitions. And there were certain red lines which helped international law more or less exist even during the Cold War period. So, now the situation, in my opinion, is even worse. Of course, even during the Cold War, the world was not built on international law. Maybe peace was guaranteed more by the mutually assured destruction mad concept in the presence of nuclear weapons. But nevertheless, international law worked. So, now when the situation in the world has changed since the beginning of the 1990s, especially. This was this long unipolar period in the world history, I believe, a decade, long decade in the world history, when there was no balancing against one center of power. Now China has become much stronger. Russia had come out of the shock of this of the 1990s, and therefore there is this struggle between two different visions in the world. One is the unipolar world, and the other is a multipolar world, and there is really very little place for international law today. This doesn't mean that international law doesn't work at all. One of the most famous international lawyers also, Louis Henkin, at the end of the 1980s probably, he wrote that most of the states observe most of the time most of the norms of international law. It may still be true, but it is that some very important states today ignore the most important norms of international law. And this is the problem with international law today.
I was wondering if, because you mentioned this changed in the 90s, but within, running parallel to international law, you have, security studies in which in the early 90s, in the lieu of all this new optimism, we introduced this concept of human security instead, because international law is built around the sovereignty of the state, which the state is the entity to be secured. So obviously sovereignty is the key principle, but with human security, looking at the individual as the object to be secured, it ultimately comes in clash with sovereignty, wouldn't it?
It comes, yes, but the problem is that there is no world government, and I believe this idea, which was promoted by many for decades in the past century, it is a utopian idea, and also I believe, like most utopian ideas, if somebody tries to put them into practice, they become very distorted. Like there is nothing wrong with the ideas of communism, but when the Soviet Union wanted to, Soviet leadership wanted to put it into practice, it became something different. Similarly, the world government, this would mean that the US, through its allies or subordinates, I would call even not allies so much, would rule the world. Then this would be the world government. And now we see that there is a backlash to this idea of, let's say, diminishing sovereignty, or as many authors wrote such books with the title The End of Nation State, or meaning the end of state. There were at least two books by one Japanese and one French author, very famous, both, who had the same title of their books, and many articles were written on it. And now we can see that the the state sovereignty has become more important even in Europe. There are, though probably this is one of the European problems, that elites are more cosmopolitan, and most European peoples, at least significant parts of European nations, they don't want to give up their sovereignty. And if you take seriously, Macron, for example, President Macron is very European and cosmopolitan, but he will not give up his French seat in the UN Security Council with its veto right of veto and give it to the European Union, or simply get rid of this principle. No. And we can see that after this this idea, which was very popular in the 1990s, especially, that the state sovereignty disappears, or the states disappear at all. And this was like communists or Bolsheviks also advocated this idea that under communism the states would disappear. But that didn't happen, and I have even written several pieces, probably, that it is too early to send the state into the dustbin of history. So the states are coming back.
I was wondering if I could just go back to the point that you were making about the Cold War and the fact that we had a period of stability then, in a kind of stability, a very dangerous and in some ways frightening stability, but it did exist. And I'm going to say that I've always felt about international law that it has a connection, a kind of symbiotic connection to peace, the preservation of peace, in the sense that in order for international law to function at all, you have to have a state of peace. Peace is indispensable to it. And at the same time, without international law, you can't really have peace. Peace is, to a great extent, supported by international law. The two, as I said, come together and they support and buttress each other. Whereas if you get a state of conflict, if you get a state of war, then eventually what happens is that law itself, you move into a kind of condition inexorably of lawlessness. And I have to say, I felt in the 90s that was lost, and that statesmen, state political leaders, especially in the West, including, by the way, in Britain, stopped prioritizing peace. And they weren't so interested any longer in preserving peace, which had been the main priority during the Cold War. And they thought that they could reshape things in all sorts of ways. And because they no longer prioritized peace, they no longer were concerned to maintain international law as it had previously been understood and existed, and wanted to shape it also into something else. And it all came together for me in a speech which I'm sure you remember, which the British Prime Minister at the time, Tony Blair, gave, I think, in Chicago, in which he was basically talking about a completely different system of international law, which for me wasn't law at all.
Yes, you are right. Tony Blair made this speech, and I recall now another speech which was made by Theresa May, the Prime Minister of the United Kingdom, also when she was for a short period the Prime Minister. She was also in the United States. I believe it was in the White House meeting with the President of the United States. And she said that the period when the United States Trump was president of the United States, then Donald Trump, that the period when the United States and the United Kingdom used military force in the world in order to promote democracy and human rights, this period is in the past. And then I felt more optimistic. I thought that maybe this is now, they have come to the understanding that this idea of including using force and economic pressure and sanctions in order to promote democracy and human rights in the world, that this idea in practice didn't work, or in many few cases only. I wouldn't say that the British leadership, I have lived, and I am not speaking from London, and that the British leadership didn't want peace. But they wanted a different kind of peace, just peace. And therefore, even the old religious idea of just wars made a comeback in the discourse, not only legal but political discourse, that the triumph of liberal democracy and market economy can be promoted, and this inevitable progressive direction can be accelerated, sometimes using force against certain regimes, putting pressure on other regimes. This probably was what was going on in at the end of the 1980s and in the 1990s. The interpretation of international law also changed accordingly, because there was nobody to say seriously anything about it. During the Yeltsin period in Russia, and Chinese have been silent. Then they followed Deng Xiaoping's the sayings to remain silent, to keep building up economic strength, and therefore, it seemed that the world was going in that direction. And this was, I would say, the Fukuyamian vision of the world development, evolution, that there would be, the world will become inevitably liberal, democratic, and free market oriented. And it was necessary sometimes to help, to push in some parts of the world to accelerate this coming
But
future. So this is my interpretation maybe of this period.
But do you see then international law to some extent being a reflection of the international distribution of power? Now I'm asking because to a large extent you mentioned, there's no world government, so international law, given that you have to be voluntary, it implies you give up some of your foreign policy flexibility, and in return you get predictability as there's reciprocity. But under a balance of power, you would assume that the international law would then be focused on the rules of the game being mutual constraint. So I accept constraint on my part and you on yours. But in a unipolar system, the one that emerged in the 90s, a lot of the language was revolved around the optimism, of course, about human rights and elevating the individual, beyond merely having this state concept of security. But if you have a distribution of power in which one side is dominant, there's no incentive for them to accept constraint on themselves. So under a hegemonic situation, would you have incentives to construct a new international law, if you will, one based on sovereign inequality, one in which, the hegemon maintains their sovereignty, while the rest diminishes theirs. Because I'm thinking in the 90s, a lot of the concepts that kept coming up in terms of policy, from humanitarian interventionism to democracy promotion, and later on you had the justifications or legitimacy around the global war on terror. The common denominator for all of them appeared to be, we will maintain our sovereignty, while the sovereignty of the rest will be conditioned or limited.
Glenn, you are correct, but I would add to here that many people genuinely, even politicians, genuinely believed that they were in the right side of history. And those who thought differently, behaved differently, they were in the wrong side of history. So why to make compromises? This is like, I remember I read Lenin decades ago, and then there was that Lenin explained that if you are absolutely sure that your position, your ideas are correct, so why do you make compromises with people who have wrong ideas? So I believe this was genuinely believed by many, but also hypocritically then, because they were not only ideas, but interests, oil, domination, strategic interest, and so on. But there was genuine belief among many people in the West, especially, that what the others want, or they are wrong. Simply, you have to explain to them, and if they don't understand, you can push them or even sanction, and in some cases to use military force to change the regimes. So, for example, I still have some books, though I haven't read them, about the democratizing, starting to democratize Iraq, and then the wider Middle East when Iraq becomes democratic. I couldn't understand it even then, but now we can see what happened with such states like Iraq, Afghanistan, or Libya. So no intervention has made the world better, and those states have become all failed states where Western interventions have taken place in the 1990s and 2000s.
Let me just quickly say, I don't doubt that it's a genuine, this idea that can genuinely change the world by elevating human rights in international law. So I don't doubt that many take this very serious. I think there's a bit of a conversion of it, not conversion, a mixture, if you will, between the idealists and the neocons. But obviously, I don't doubt that there's a huge amount of people who are very genuine about this optimistic view of international law. But I'm sometimes reminded of John Hertz. He wrote in the 1940s that this makes it, even when they're genuine, it can be even more dangerous, because if you see the difference between the corrupt world of today and the utopian world of tomorrow, if you can cross over, it legitimizes quite extraordinary and aggressive means. If you think that you can transition from this current flawed world to a more of a Fukuyama world, if you will.
Sometimes genuine believers are most dangerous people, while corrupt, you can maybe deal with corrupt leaders sometimes. In history, you can see sometimes foreign leaders were bribed and peace was agreed because of such bribes. But I am not saying that that's good or necessary. But one of the philosophers has said that let's say non-believer may be a serial killer, But in order to have somebody to commit genocide or crimes against humanity, you have to be a believer sincere believer in the correctness of your beliefs. Yes, but this is maybe extreme, but maybe simply on concluding on human rights. I don't believe that all human rights norms are necessarily universal, and they can be immediately be accepted by all societies in the world. Jonathan Haidt, one of the American social psychologist, has written that even in today's world there are at least 3 groups of societies. One based on individual liberties, the second on collective interests, and the third on religious beliefs. And therefore, to have the same rules, internal rules, I mean not rules of international behavior, but internal rules in all these groups of states, it is a utopian idea, in my opinion.
Can I just say that just briefly that my own experience of deeply ideological or idealistic people, whom I have encountered many times, by the way, is that always at the end, deep down, there's always a core of cynicism, which always exists. The fact that they are so ideological and idealistic leads them on to do things that no one else would seriously do. And it also makes them more resentful of limits on their behavior than perhaps more, shall we say, worldly people might want. And for me, by the way, I should say, law for me is all about limits. If law takes away limits, then I don't see what law it can be. But can we move to a sort of practical example? Because, Blair made that speech over the course of a war, which is the war that was being waged against Yugoslavia. It was a bombing campaign against Yugoslavia. Yugoslavia had not attacked any third country. There was an internal conflict within Yugoslavia in Kosovo. The Western powers spoke about this conflict very much in terms of a genocide that was allegedly taking place there. Blair made his speech saying that the Westphalian Order, I don't personally think it has anything to do with Westphalia, but the Westphalian Order of the sovereignty of states really needs to be taken away. And it was justified in those kind of terms. And then afterwards, of course, it turned out that many of the claims made about what had been going on in Kosovo were profoundly exaggerated. We never quite found out whether the people who made them believed them, or whether it was that there was, perhaps they believed them, or perhaps they exaggerated them, or whatever it was. But despite all of that, they never came back and changed their views. They never said that the Kosovo War was a mistake. And realistically, politically, they couldn't have done that. It would have affected them personally if they had. And in fact, they've just continued so that the war with Kosovo ended. There was a UN Security Council resolution which basically said Kosovo will continue to be a part of Yugoslavia and then of Serbia. And then, of course, eventually we got into a full declaration of independence for Kosovo. All of these stages along the way. And then I would really like to ask you what you think about this last thing. We had an advisory opinion about Kosovo from the International Court, which I have to say I found when I found it, I was rather disturbed by it. But anyway, I mean, a lot of things to cover that question. But I mean, yeah, let's give you. I'd be interested to know what you think about Kosovo and the whole Kosovo situation and that advisory opinion in particular.
Well, it is a very important question or important stage in the evolution of international society, I would say, and international law too. Of course, in Kosovo, there were many human rights violations from both sides, by the way. So there was a Kosovo Liberation Army, if you remember, which was under President Clinton, it was declared a terrorist organization. So, and the leaders of this terrorist organization later became leaders of Kosovo when it became de facto already independent from Serbia. So human rights violations were serious, but they were committed by all the sides. But the problem is that if you say that all of them are equally bad, or if some are even worse, but others are bad as well. So you can't mobilize the public opinion, you can't mobilize international opinion for your cause. So therefore, in the case of Kosovo, all the atrocities which were committed, and they were committed by the Serbs, they were reported, exaggerated often, and all the atrocities committed by the other side, by the Kosovo Albanians, they were usually simply silenced. I remember that during that period, even the foreign secretary in the United Kingdom in Parliament, and it was not reported widely, only specialists. It was in one of the parliamentary committees. He said that every time when under the international pressure, the Serbs pulled back, the Kosovo Liberation Army steps in and fought the Serbs, both the army, the police, and also the civilian Serbs in Kosovo. So, and then, yes, NATO decided to use military force. There was no resolution of the Security Council authorizing these, what's called all necessary means to resolve the problem. And this was contrary to international law. Certainly, NATO took one side against the other side, the Serbs, and mostly for political reasons, of course. In my opinion, both parties in Kosovo had equally committed atrocities. And now coming back, okay, this was contrary to international law, but after that, even when negotiations started, then you refer to the Security Council resolution. It was 1244, if I am correct, in June 1999, which confirmed sovereignty and territorial integrity of Serbia. That was Serbia-Montenegro at that time. They were together still. But 8 years later, approximately, during this period when NATO and the European Union ruled in Kosovo, then in 2008, if I am correct, these leaders of the Kosovo Liberation Army, they declared independence of Kosovo, which was soon recognized by most of the European states, by the United States, by most Western states, and especially also Muslim states recognized independence of Kosovo. Now, and then, of course, you also mentioned this famous advisory opinion on the independence of Kosovo. But it is very interesting. This advisory opinion was asked by the General Assembly. The question was put to the International Court of Justice whether declaration of independence by Kosovo violated any norms of international law. And the court had only, if to ask this question, you have only one answer. No, it doesn't. I am in London in my house, a very small plot of land. If I declare this part of London independent from the United Kingdom, it doesn't violate international law. It has nothing to do with international law. But if, let's say, Putin or Xi Jinping recognize my independence and even help me to, let's say, to carry on as an independent entity. This is contrary to international law. So therefore, I would say NATO states violated international law when they used military force in against Serbia over Kosovo, and all of those states which recognized independence of Kosovo also violated international law, because international law doesn't allow parts of state to declare independence unilaterally, and then other states could recognize. This is usually, or has been practically always until recently, the practice. After Kosovo, this practice was broken, or this tendency. And then Russia recognized independence of South Ossetia and Abkhazia, also in 2008 already. And then, of course, it was easier for Russia maybe to explain these referenda in eastern Ukraine and then recognizing their independence and then to accept their desire to join Russia. So this is, it also, in my opinion, it started from Kosovo, though I remember Condoleezza Rice said then she was the Secretary of State. She said that Kosovo is not a precedent for us. And then Sergei Lavrov, similarly, after recognition of independence of Abkhazia and Southern Ossetia, also said that this is not a precedent. This is a unique case. But you know, international law evolves through precedents. And sometimes, thank God, there are few precedents of use of force. So therefore, every case counts. Maybe they don't create new law, but they undermine existing restrictions. So this is dangerous, and therefore I believe Kosovo was a very, very bad case in all respects. And I would say that following in Russia, in my opinion, the public opinion, Russia, then even those who were against the government, well, let's say liberally minded people, they also already at this view that use of force may be not prohibited. This prohibition is not absolute, and therefore this led to this, I would say, negative evolution of the Russian society as well.
Well, I thought that, from my perspective, one of the dangerous precedents of Kosovo, and I agree, this is, for me, the point, the ground zero, effectively, is that, as you said, it was not legal, the invasion in 1999, but the argument was that it was legitimate. I always thought that this was interesting, that by decoupling them, legality from legitimacy, because the legitimacy was obviously rooted in humanitarian law or human rights, and because you also pointed out that there's a tendency to exaggerate on one side and cover up almost for the other, but this seems to be built into the system. If legitimacy to override international law or create a parallel international law depends on violation of human rights, you would always have the incentive to exaggerate and be very one-sided, and this also then leads to very skewed media coverage, I would say, because if the legitimacy to replace international law depends on human rights violation, then effectively what makes something legitimate? It effectively becomes a tribunal of public opinion. If you're able to convince the public that here human rights abuse have occurred, then you have kind of authority to use this alternative or human rights law to supersede international law. But also, yes, a wider implication, I think, what happened in Kosovo, because when the Americans invaded Iraq, they were discussing this, because this coalition of the willing, it was not really a very strong source of legitimacy. So, this is when they began to discuss, we have to recreate some of the legitimacy we had from Kosovo. So that's when we start to talk about, alliance of democracies, concert of democracies, league of democracies, all these different concepts of essentially creating one set of international law for the liberal democracies under American leadership, and another set of international law for the rest. Because, and I don't know, from my perspective, this kind of reflected in the international rules-based order, which is always promoted as well by Washington, that you have two sets of international law. Because if legitimacy is rooted in liberal democratic values, then it implies that the West, as the champions of liberal democracy, kind of can claim ownership to this ideal. So you have an ideal of human rights linked to an entity of power. But I'm not sure if you agree, or if what the solution will be to this, though.
Yes, one of the aspects of the Kosovo crisis or use of force there is that after international body was set up, commission to study the legality of NATO's bombardment of Serbia. And this was led by Richard Goldstone, the famous South African lawyer and the first prosecutor of the International Criminal Tribunal for the former Yugoslavia. They made this conclusion that the operation was illegal but legitimate. So that in my opinion, I have thought and written a lot about it. So the idea is that there are some higher values than legality or a law. For example, public disobedience in certain cases, people violate law for higher values, moral values. This may be, they mostly violate domestic laws. So, and similarly, it was understood in such a way that there is something higher than formal legal norms, and therefore they can be put aside in cases of, for example, humanitarian intervention, as the Kosovo operation was presented very often. And it's a very dangerous development, of course. And after that, now, also, I am a member of the the Institute of International Law. I was even president of it for a while in Geneva, which consists of 130 international lawyers all over the world, and we discussed these issues, and now most international lawyers have given up this idea of humanitarian intervention or even responsibility to protect. So in one aspect, at least, that you cannot protect through use of military force. And Kosovo and other such cases, which all failed, by the way, in terms they didn't change the situation for the better. I have studied and written a lot about it. I would say shortly that, in my opinion, three significant uses of military force have made human rights situations better, a bit better at least. This is when India intervened in eastern Pakistan in 1972, and then Bangladesh emerged as an independent state. Then Tanzania intervened in Uganda, overthrowing Amin. And finally, Vietnam intervened against the democratic Kampuchea or Cambodia, and now overthrowing Ieng Sary and Pol Pot. These were interventions which were not regime change interventions. They didn't lead to emergence of democracy in these respective states. And these neighboring states which intervened probably knew much better the situation on the ground than a NATO or a Western state intervening in Iraq or in Afghanistan. So no military intervention, Western at least, military intervention has made the situation better in the states where the interventions took place and in the world.
Yeah, can I just make a quick observation about those three examples? Of course, in two of them, the Bangladesh War of 1971 and the Cambodia War, the Kampuchea War of, I think that was also, well, it was in the 70s. Of course, the United States, of course, was opposed to them. It continued to criticize both of those interventions. I mean, it continued to deny the legitimacy of the government that was established after the Vietnamese invasion in Kampuchea. And of course, it supported Pakistan in the 1971 war. I just mentioned this little historical point, but I have to say,
your intervention is very interesting. Yes.
Yeah.
For example, of course, the Vietnamese intervention happened in the context of the Cold War, because the Soviet Union was the Vietnamese ally, and therefore, of course. But it is interesting. I read later, and it was the diplomats of Belgian government and Australian government. They regretted that their governments had then in 1979 been critical of the Vietnamese intervention. And this was in the context of the Kosovo. So you can see that Brussels, not the European Union, but Belgium in that case, and Australia, their governments felt that they had been wrong then going with the United States and the US, kept Pol Pot, the government of Pol Pot King Seri, in the UN for several years after they were already overthrown by the Vietnamese intervention.
But this is, I'm thinking this also of, a quick point of the a common concern about peacekeeping would be always that there's always a dilemma. So if states don't have an interest, why would they sacrifice their blood and treasury to send their soldiers? Meanwhile, if they have an interest, why would they act neutral in this conflict? So, but of course, but that would be peacekeeping. But of course, if you take it to the higher level of interventionism,
of course, I agree completely. India, Vietnam, and even Tanzania, they didn't intervene purely for humanitarian concerns. They had other interests in play. But it so happened that after these interventions, things became a bit better. I
just wanted to say just 2 quick points. Firstly, I mean, the idea of legality emerging out of legitimacy, I mean, seems to me personally a logical and linguistic absurdity. I mean, legitimacy is something that comes from law, surely. I mean, it's not the other way around. But anyway, my major focus is this concept of this rules-based international order. I wanted to ask a question because I've seen lots of people refer to this thing. I've never myself come across an actual definition of it. I've never seen somebody sit down and explain what the rules-based international order exactly is and why we need to use that expression at all instead of simply talking about international law. Why do people talk about the rules-based international order if they mean international law? And if it is not international law, then what is it exactly?
I agree with you as an international lawyer that's and at least it should be the case that legitimacy and lawfulness they completely overlap. So this is in international law. Maybe sometimes, if I may give you an example, the emergence of exclusive economic zones and other maritime boundaries. So they emerged through the violation of international law, of the international law of the sea, because there was all an open sea, and suddenly, and these were not Western states or great powers, these were Latin American states with long coastal lines. They wanted to have some benefits from having these long coastal lines where the Soviet, the American, British vessels fished. And they started establishing these zones contrary to international law. And finally, through these violations, they were not so serious violations as use of military force, for example, but nevertheless, they were contrary. These laws were contrary to international law, but they probably corresponded to certain evolutions of international relations related to these problems. And these violations led to the emergence of new rules of international law. So it may be in international law that this happens. So, but these main principles of international law concerning use of force, non-interference in internal affairs, and sovereign equality of states, I believe these are these ground norms of international law which should not be violated by anybody.
As we spoke before about the president of Kosovo, I thought, well, we can't really do that without speaking about Crimea, because this is a common comparison. I was, as a international lawyer, I was curious about your perspective, because, of course, when Russia recognized reunified with Crimea, the argument was, well, this can be compared to what the West did in Kosovo, and similarly, 8 years later. When Russia invaded in 2022, it also used some of this precedents set in the West. So first, it recognized the independence of Donbass, justifying it by the 8 years of human rights abuse and the shelling of Donbass, and then claimed the right for self-defense in cooperation then with Donbass. So it's especially focusing on the similarities between Kosovo and Crimea, possibly less controversial. How do you see the similarities? Do you buy the argument by Moscow, or what are the weaknesses in this argument, or how do you see it?
There are weaknesses in all of these arguments from the point of view of international law. I recalled, when you asked this question, I recalled what Dean Acheson, the former Secretary of State, said about the Cuban Missile Crisis. In 1963, during the meeting of the American Society of International Law, he was asked how this American behavior of the United States during the crisis was in accordance with international law, wasn't it? And because from the point of view of international law, the Soviet Union had the right to establish nuclear missiles on the Cuban territory, because Cuba was agreed on this. It was so in accordance with international, though it was secret. And Dean Acheson responded to this question that this was not a matter of international law, because I don't remember exactly the wording, but because the prestige and vital interest of the United States were in play, which come close to the sovereignty of the state. And therefore, it is not for international law to resolve such issues. I believe that Mr. Putin would have been probably more correct to quote Dean Acheson, but I was Gorbachev's legal advisor, not Putin's legal advisor. So therefore, I would say that Putin should have used probably this term. But he made, in my opinion, the best geopolitical joke in his speech. It was on the 18th of March, probably of 2014, about this reunification or occupation of the Crimea. He said that the American Marines are generally great guys, but he would prefer to invite them to Sevastopol instead of being invited by them to Sevastopol. This probably is their reason. And all other religious arguments, historical arguments, yes, they are for the public consumptions in Russia and maybe beyond Russia. But this, in my opinion, was really the essence of this reunification of the Crimea with Russia. And so, yes, it was contrary to international law, though there may be, and what happened in eastern Ukraine, in Donbass area, these referenda, I would say that Russia has more often than the West referred to international law, while the West refers to rule-based order, which is not very clear what it is. So, but also Russia interprets and twists international law in accordance with its own interests. So it may be, let's say, I would say, so that it is how to put formally correct, but in essence, it is a mockery of international law. And Russia is not alone. Russia has had very good teachers in that respect. Yes, you organize referenda, then people vote. In the case of Crimea, certainly, I believe most people voted genuinely. But in any case, it was through the threatening presence of Russian troops in the Crimea. And then you recognize their newly acquired independence, and their desire to join the Great Motherland. So, yes, in accordance with international law, maybe formally, but in essence, a mockery of law.
How about I heard the argument before the parliament that the Crimea has a unique, under Ukraine had the unique authorities or autonomy, that they had its own parliament. I never really delved into this argument. I'm not too familiar with this argument myself. I was wondering, is this valid, that the Crimean parliament had the authority to push for independence on its own, or?
In my opinion, no parliament in the world today has this authority. So we can see now in the case of Scotland, probably today it will be resolved who will be the new leader in Scotland. They want to become independent. The parliament in Westminster says no unilateral independence, and the Supreme Court has said so. There is no right to independence, though it may be possible, like in the case of Quebec, they have a referendum, and the Scots had their referendum here. But it doesn't mean that there is in international law or in domestic constitutions of any state this right of parts of the state, whether they have a certain autonomy or not, to become independent. Well, for example, it is exactly this argument that Quebecois have used often, that they have everything. They have their parliament, they have their government, they have their borders, and so on. Now, the only thing is to become completely independent. But why Turks don't allow? And then they have their own language also. They speak, most of them speak French. But then when the Kurd wants something to speak their own language, be it in Turkey or in some other states, so these governments say, look, or think at least that, look, the Quebecois have their own language, their borders, their parliament, their local authorities, and now one step only remains toward independence. And so, therefore, they don't allow their minorities to have these all things which they consider as steps towards claims for complete independence.
I should say that I think the Russians know perfectly well that both in Crimea and in Donbass, they're treading on very thin ice internationally. But I think they also probably calculate that enough precedents have been created that And most people can see that there were those national security concerns, and that they can just manage to get by. It's a real politic thing, if you like. They know that the Indians, the Saudis, the Chinese, the Africans, the Latin Americans, they're not going to be too concerned about this. And I'm going to suggest one reason why, and that is that one thing that the Russians have not done is that they've not frontally assaulted international law. They talk all the time about international law. They talk all the time about the primacy of the United Nations. They don't talk about a rules-based international order, which none of us really knows what it is. They don't talk about a situation where there's rights to protect, even though that we hear less of that nowadays. But by the way, in terms of the British government, I don't think it's gone completely. It still comes up from time to time. But the Russians have been very, very careful, as Acheson was all the way back in the 60s, not to say, I'm creating something new. International law has had its day. It's over. Westphalia is obsolete. It's an old treaty from 1648. Nobody cares about it today. We're living in a completely different world. We have a new system. This is the rules-based system, whatever that is, and I'm going to decide what that is. So I think that's where, if you like, the Russians have been more astute. They've got it more right than the Western powers have. I mean, would you agree with this? Because I do get the sense that most countries around the world do prefer a system where there is an international law that everybody nominally can adhere to.
Yes, of course. I agree completely with you. And also there is a certain value in this, that Russia refers to international law and tries to show that it is not violating international law in these all situations. But also this is a kind of, especially what I say, using this very loose definition of the right of people to self-determination, that these minorities have the right to independence, and then they can choose whether to join other states or not. Of course, there may be, from the point of view of international law, there may be one argument in favor of the Russian position in eastern Ukraine, is that during 8 years, the authorities in Kiev bombarded these territories. And in 2014, even they used aviation to bomb the airport in Donbass and in Donetsk, the airport in Donetsk. So, therefore, there is one, what in law maybe it would be called a residual right to independence. So there is a right to self-determination, which usually has to be acquired within existing boundaries, without changing boundaries, at least against the will of the states. Now, when somebody is not allowed to express their views, and they are oppressed, as people in eastern Ukraine were since 2014, when the conflict started, then they didn't have any other option. And certainly Kiev didn't rest them other options, either to surrender completely or you have to face this shock and awe in the way of constant bombardments and military conflict in these territories. So this may be an argument, let's say, in favor of certain independence, because, for example, when and it is an interesting maybe fact that the referendum in Scotland and the conflict in Ukraine, they start in 2014. They coincided partly. So, and I thought maybe I have written about it that what the government of the UK. They didn't want Scotland to become independent. I remember Gordon Brown and others. They Labour leaders. They went to Scotland to advocate no vote for independence. They did everything, but they didn't start bombing Scots into obedience. So. But this is how the Ukrainian government then in Kiev reacted to the desire of those in eastern Ukraine to become independent, or at least autonomous, to become autonomous within the frontiers of Ukraine. So, and in my opinion, this was also that maybe even in Britain, like in other Western countries where these independence movements exist, they didn't say anything against the government in Kiev. It was not criticized. Always, even the non-observance of so-called Minsk agreements, it was that it was Russia and the rebels who didn't respect these agreements. But now we know that Merkel and Francois Hollande, they both said that the Minsk agreements were not to be implemented by the West and by Ukraine at all. So we may come to the conclusion, yes, that there may have been this residual right of these people to fight for their independence, and then Russia to support this fight.
Yeah. Because the Minsk agreement was also signed, was agreed at with the United Nations. So wouldn't that also make it part of international law in terms of? I'm thinking now that. The argument was often made that Russia didn't follow it, but Russia's not mentioned actually in the Minsk II agreement. But I was wondering, given that these agreements, set their clear conditions, what Ukraine was supposed to implement, the French and the Germans, the one who negotiated this agreement, they signed the agreement, and now, of course, they go back and, whether or not they're genuine in what they're arguing now, which is, we didn't intend that this would establish peace. It was meant to rearm Ukraine to effectively I assume then to resolve this by military means. Isn't this also then a breach then of international law? Not that, one justifies the other.
Yes, of course. The Minsk agreements, Minsk II, so-called, was legally binding, and maybe that it was also supported by the United Nations. It came additional, let's say, strength to it. But this was a legally binding document. And yes, and mostly it was not observed by Kiev, and neither Germany nor France. In my opinion, I don't remember having ever criticized Kiev for the non-observance of the Minsk agreements.
Because I'm thinking, is how would you see us? Do you see an international law as an instrument to get out of this conflict? Because from my perspective, I guess the collapse, or not collapse of international law, but ignoring it has been part of the reason why we ended up in this place. Because first of all, if of course, in the West began in 2014 to very much instigate this to destabilize Ukraine, to will definitely interfere in their domestic affairs, leading to the toppling of Yanukovych. Even though we had disagreements as well the day before he was toppled, that they would have a unity government. So we broke kind of all we interfered in their domestic affairs. We broke the agreements. Then, of course, Russia took Crimea, which is then also seen as a breach of international law. And then we have the Minsk agreement. They were signed, were not intended to be honored. And this seems to me to be international law unraveling. How do you see us? Well, for both of you, I guess. How do we get out of this trouble? Or, I'm not sure how to put this. if the failure of international law got us into this, is there? How do you see?
International law certainly has failed. In this case, and I believe it started failing already. Let's say a certain undermining of international law started already in the 1990s. So precedents started emerging, and then these violations of international law. Or the non-observance of the Minsk agreements and referenda, which are not in conformity of international law. And I would say, yes, now compromises are necessary. International law is always based on compromises. And without them, you can't come out of the conflict and have peace. And then international law comes into play, and should confirm these compromises made by the parties to the conflict. So this is the only way to come out of this conflict. And in my opinion, really the first step should be to stop fighting, to have negotiations. I was very optimistic, not very, I am exaggerating, slightly optimistic it was in March of a year ago when the negotiations were taking place in Istanbul. And by the way, I saw for the first time in the Ukrainian side some people around the table who were not present before. I am not naming the names now. I knew these people very well years ago. They were new faces during the negotiations, and these were moderates. These were not hawks from the Ukrainian side. And I thought that now things may change. But then Boris Johnson flew to Kiev, and everything collapsed. The negotiations collapsed. But this is how things should be, and hopefully, maybe China would help here. I taught international law, use of force, international criminal law in London already in the 1990s. And one of the causes was the conflict in the Middle East. And my students always asked when the Arab countries and Israel may make a peace. And I jokingly said that when China takes over the role of the mediator instead of the United States, because the Chinese don't have enough Jews, they don't have enough Arabs in their country, so therefore they can be impartial. And my joke, which I didn't believe much then, it was 20 years ago, let's say, maybe. But you can now see that the diplomatic relations between Saudi Arabia and Iran became a reality thanks to the Chinese intervention. China has its role to play also here, and it can China can have an influence on Russia, certainly, and also in Ukraine. Though certainly the West and the United States don't like it, but nevertheless, maybe this may start the ball rolling in the right direction sooner or later.
I'll just add my own little say on this, which is, first of all, I completely agree with what Rein Mu has just said. Negotiations. We need negotiations to achieve peace. Now, once that has been achieved in Ukraine, it can only really be consolidated if there is a proper peace in Europe. That is to say, a fundamental restructuring of the security and legal architecture in Europe. And that requires negotiations and discussions between the great powers, obviously. The Chinese may have a role to play there as well, but the United States, Russia, Germany, France, Britain, all of them, they need to come together, and they need to come and agree a system that will be able to control conflicts in the European area in the future, and at the same time will allow states and people within those states to feel secure. And can I just say, this is a point perhaps of optimism, because it's often the case historically that conflicts do actually eventually create precisely those kind of peaceful structures, those structures that support peace, which is what we have been lacking so much now. So if you put it like that, you can also see the importance of international law, because any security structure, any legal structure that I'm talking about, would be one which, by definition, would be anchored in international law. If states all agreed with it, if it was all sewn together in treaties, then it would become part of the international law system, along with everything else, with the UN Charter, with all the precedents, with all the other things that make the web of international law that we all know.
Yes, you are absolutely right in that respect. And I would say that fortunately, the Cold War was only Cold War. And unfortunately, it ended also in such a way that it was not necessary for those participants to come together and to create new security structures for Europe or for the world. So there was only one triumphant side, a winner in this Cold War, and therefore there was no need felt that there should be a new structure, and therefore things remained in law as they were, but the situation in the world had changed considerably, and now we see that hopefully, maybe after the conflict in Ukraine, which is not about Ukraine so much as it is about the new or about the world order, what kind of world we will have if there is no, thank God, maybe a nuclear war, that what kind of order there may be. Whether this, let's say, earthquake is serious enough to force world leaders to come together and to create new security structures. By the way, I would like maybe to say I have read Henry Kissinger recently in his book Leadership. He bemoans really that there is no political leadership in the world. like Churchill, de Gaulle, Adenauer. There were and Nixon, of course, he refers to Nixon, and there aren't such leaders in the West. In the East, they are not the best very often, but they may be strong enough to be able to agree to something, but I don't see really. I agree with Nixon. I don't see in the West leaders who would be ready to sacrifice, maybe to have a vision first of all, and then to sacrifice their. To be ready to sacrifice their political positions in order to make decisions which are necessary.
I think part of the problem is, though, we embrace this ideology too deep that the world is always divided between liberal democracy and authoritarianism. So if you challenge the mere concept of this rules-based international order, understood as the decoupling of legitimacy from legality, it seems like it becomes an impossible thing for any political leaders to do, because at least the way I see it, often the problem in international law is exactly that we got two sets of international law. Well, one example would be the Budapest Memorandum, because Russia is, it's Russia, the UK, US, they all signed the Budapest Memorandum, for example, that every side would respect the territorial integrity of Ukraine, but as well as Belarus and Kazakhstan. But it also said there shouldn't be any economic coercion to decide to subordinate their interests, or any threat of use of force. So, anyways, the counter argument often, this is the argument against Russia, but the problem is, of course, often that the West that didn't follow this either. They put not just the pressure on Ukraine, but actually in 2013, when the US put its sanctions on Belarus, it's actually written on the American Embassy's website that this is not a breach of the Budapest Memorandum. First of all, it's not really international law. We don't have to follow it. But also, we don't try to subordinate their interests to our own. Instead, our objective is merely to advance humanitarian values and liberal democratic norms. So as long as we have this idea that these liberal democratic values becomes an alternative source of legitimacy instead of law, you will always have two sets of international law. And I'm thinking also now that Russia and Belarus are announcing they're going to place Russian nuclear weapons in Belarus. There's immediately an outrage, but we have the same in the West. We have NATO's nuclear sharing. That is, if you look at nuclear proliferation treaty, Article 1 and 2, it's very clear you should not place nuclear weapons in non-nuclear weapon states. But with NATO's nuclear sharing, the Americans have their nuclear weapons in Belgium, Netherlands, Germany, Italy, and Turkey. So that there's always this two sets of international law. My concern is if we're going to walk this back and agree on common rules, it has this ideological barrier. We would have to first pull back on these liberal democratic ideas that we use for an exemption, though, from international law.
There is law is a formal institution, more or less, differently from all other normative, let's say, concepts like morality or other norms of behavior. And there is certain value in this formality. So I don't like formalism, I don't like bureaucracy, but in law, this is a value. So what is not allowed to an aggressor is not allowed to also to victim of aggression. Well, for example, I would say now the conflict in Ukraine, let's say that the Western world, they speaks about violations of international humanitarian law by Russia, and even there is a calls for international tribunal for Russian leadership, but also the Ukrainian side is violating international humanitarian law, certainly. And there have been very few criticism about it. Amnesty International once, and now recently the UN, about treatment of prisoners of war by both sides. Let's say both democratic states and non-democratic states have the same rights under international law, and this division of the world, I believe it's very dangerous. And when Biden organized this World Meeting of Democracies, not only that there were not all democracies, and some democracies may have been excluded, but also the very fact is very dangerous, in my opinion. So, therefore, that you can't use military force for purposes of promotion of human rights or democracy, and you can't use military force also for the promotion of other values. So very few states use military force for the promotion of different conservative values, for example. So this is maybe very important, that to observe international law, notwithstanding of, let's say, ideologies which are dominant in different societies.
I like the way you framed it better than that. Yeah, the introduction of morality and the normative arguments into international law, it can easily make it, make a mockery out of international law, to steal another phrase from you, because this is what I noticed with this humanitarian the investigation of Ukrainian conduct during this war, because usually they divide into two different set of rules. You have jus ad bellum, which is the rules of going to war, and jus in bello, if I'm not mistaken, the rules of once you're in a war. And I was making the argument as well that a lot of the things Ukraine has done in terms of putting its weapon systems in civilian areas, or executing Russian troops, that this is obviously a huge breach. But then the argument is always, the Russian invaded, but this is a separate thing, and it doesn't. This idea that the one who has been invaded doesn't have any. Doesn't have the same responsibility under international law. You can make a strong normative and moral argument, but once you introduce this, you kind of undermine the whole effectiveness or the whole purpose of international law. And I was also thinking about the recent arrest warrant now against Putin. I'm not sure, how any of you two look at this. For me, just again, I'm not sure if it was just a normative or a moral outrage, but I don't see how this serves an interest in terms of many problems. One being, it seems to be very arbitrary who's actually prosecuted, which is a key feature, I guess, of the ICC, but also preventing actual negotiations to end the war. I mean, it is a lot of things, I think, that feels good or normative arguments, but it just attacks the foundation of international law.
This is really a strange situation. And what I said earlier in a different context, that maybe it is correct, formally correct, but mockery in essence, it may be also applicable here. Let's say both Russia and Ukraine, they haven't ratified the Rome statutes, so therefore they are not bound. Yes, Ukraine made a declaration which is in accordance with the statute, that it recognizes the jurisdiction of the ICC over crimes committed in Ukraine. So therefore also maybe quite ingeniously, but also mockery overlaw only for this concrete purpose to recognize jurisdiction of the ICC, thereby making it legally at least possible to indict Russians also who may commit crimes on the territory of Ukraine. You know what the US has done in that sense. When the ICC was created, the United States concluded agreements. I don't know. I don't remember now by how many states, whereby those states which had signed, ratified these agreements with the United States, declared that they will never surrender any U.S. citizen to the ICC if this citizen is indicted by the ICC and may be on the territory of this state. So it all seems to be this indictment seems to be a mockery of international law. Though, as I say, may be formally correct, because due to this statement of the Ukrainian government, the ICC has jurisdiction over crimes, genocide, crimes against humanity, war crimes committed on the territory of Ukraine. What is the result? I believe the only result, which besides the propaganda effect of it, has that it may make this process of negotiations, which should lead to the end of the conflict and then to the creation of the more safer, more secure world, even more difficult. So, though I don't think that this is a big issue in reality, it is propaganda. It has in the West, especially, it has a propaganda effect mostly, and nothing else.
I have to just quickly say, though, and I agree with that. I agree with all your points, but specifically on the last one, using legal processes to make propaganda, or if you like, rhetorical points. That's something which, as somebody who once worked in a court, the High Court in London, makes me feel very uncomfortable indeed. I don't think that is what legal processes should be used for. And I think that, again, the very fact that we're doing that at all shows a lack of understanding of how important law actually is, especially and specifically, in fact, war crimes law in this case, and what its uses should be, what its proper uses should be. Just saying again.
Exactly. I would maybe only add that though I have never been a great enthusiast of international criminal jurisdiction, as I said in a different context, that international relations between states are political, and like in domestic law, let's say political issues are resolved by constitutional law, not by criminal law. Criminal law, even domestic in these high spheres of politics, doesn't have much to say. in international relations, which are, let's say, overly political relations, even less so. And therefore, of course, we can see that the ICC has had a very little effect in the world. And if you take the International Criminal Tribunal for Yugoslavia and for Rwanda, we can see that due to the fact that in international relations, one man's terrorist is often other man's freedom fighter. And it is true. Let's take the Yugoslav conflict. All those who have served their sentences under the Hague tribunals, when they returned, let's say, to Croatia or Serbia, there is a red carpet welcome to them. They are national heroes in their own countries. So therefore, international criminal law doesn't serve the purpose domestic criminal legal systems serve. And this indictment now, I believe, maybe the final nail in the coffin of the international criminal jurisdiction, because I believe this is to have this propaganda trick will mean that the ICC will lose its remaining authority in the world if you use it in such a way. Before, the main argument was that only African leaders have appeared before the court, not other leaders. And these agreements signed, as I referred to, signed by the United States and many other states, including Estonia, certainly, and I believe most European states, so that no American serviceman can be ever surrendered to the ICC. So this makes really this whole thing as a mockery. And China, Russia, the US, and many other states have not ratified their own statute.
If I'm not mistaken, the United States even passed an act to invade The Hague, wouldn't it? Or to liberate, well, not occupy permanently, but to liberate any Americans who might be arrested by the ICC. That's what I mean. It's to see now American media celebrating this arrest warrant against Russia against Putin when by American law they would have a military intervention invading Netherlands to liberate American soldiers if they were ever arrested, and threatening prosecution against those judges. It seems, again, it's always we're going back to this topic, just or theme, just as always having these two different sets of international law, and again, I think this is also not just not to expand it further, but also the problem now with China, because often like the two key conflicting concepts now is territorial integrity versus self-determination, obviously, because territorial integrity would be a key principle of sovereignty, which is defended by international law, but by giving credibility now or legitimacy to self-determination under more humanitarian values, I guess, you have now two conflicting concepts. And it seems that whenever you choose between, do we prioritize territorial integrity or self-determination, it's always based on, it is always national interest. So, Kosovo, we go with self-determination, they can secede. We see this increasingly with Taiwan as well. Let's push for Taiwan secession, self-determination. Meanwhile, from Abkhazia, South Ossetia, Crimea, obviously territorial integrity will have to be prioritized. So it's always, quite selective.
Yes, so there are double standards on this issue, but mostly having analyzed the practice after the Second World War, at least of international law in that respect, most states have given primacy to the territorial integrity principle, the inviolability of territorial integrity over self-determination, interpreted as a right to independence. Self-determination, yes, but this is autonomy, linguistic rights, and so on, but not independence. Starting from Kosovo, and this was the most maybe damaging aspect of it, it opened this floodgate of that. And of course, the Catalonians referred to it in Iraq, a referendum on self-determination, independence of the Kurds, so on. But, the world community still in these cases remained on the side of the territorial integrity principle vis-a-vis the right to independence. So there is different interpretations of international law, and especially there is different interpretation of facts in the light of international law, even if we agree on international law, but facts may be interpreted differently and are often. And especially now I would say that the propaganda is everywhere, and it is very difficult to find out what the truth is, not only in the battleground, but elsewhere as well. So it is very difficult to make definitive conclusions on this matter. What is, I would say that what is really important is to start negotiations now, and it would be better to start them without much publicity, because usually the best solutions have been found, like we can see in the case of the Caribbean crisis and in many other situations, when the public is not informed and negotiations start, then compromises can be made, because you always find somebody who would like to break these compromises, not to fight against them. So whoever it may be, from all the sides, usually.
That's one of the, for me, one of the wrong lessons after the Cold War, because then we had the idea was that simply measuring international law and international affairs in very pragmatic national interest, that this was, immoral, that we had to aspire for higher humanitarian values. Again, a lovely sentiment, but when you have focus on pragmatism and national interest, you can negotiate with the counterpart, you can make compromises for the benefit of peace. However, when everything is measured in values as human rights or not, then any compromise become appeasement. Every conflict is between good and evil. It's just it becomes impossible to give an inch, which is why I very much agree with you. I think in those circumstances, any negotiations would have to be away from the cameras at least, so politicians can speak freely. Anyways, but before we start wrapping up, do you have any last things you wanted to add, Alexander? Oh, you're muted.
I'm unmuted myself. I just wanted to say this has been an amazing discussion, and thank you. I mean, I have to say, I think international law is the core of the problems that we have seen today. I think there's been a flight away from it, actually. I think a lot of the trouble that we've seen in the international system over the last 30 years is precisely that people have forgotten how important international law is, and one gets a sense that there's a sort of they resent its restraints. They think that they shouldn't be subjected to those restraints. I just wanted to finish. There's a very well-known film that was published in England back in the 60s about Thomas More, who was who was the Chancellor, Lord Chancellor of England. He was the head of the judiciary in England in the 16th century. And he's a very famous person for all kinds of reasons in England. Anyway, a law student tells him, I would cut down all the laws in order to chase after the devil, Satan. We need to destroy the laws. And then Moore comes back and says to him, and when the devil turns round and faces you with all the laws cut down, where then will you hide?
Very good. Very good.
Professor Mullerson, any final comment before we finish?
No, we have covered quite a lot of ground concerning international law, and I hope that really international law would prevail, but for that first peace has to be established, and it is not exactly the matter of international law. The compromises are needed, and law doesn't always give answers to these processes. So, though then the law should fix and be observed, and new structures are necessary to keep peace in Ukraine, in Europe, and in the world as well.
Yes, and I wish we had some time to discuss the gradual collapse of all the arms treaties and other international agreements, but we will have to do that for another time. So thank you very much again, Professor Mullerson. It's good to see you again.
It was my pleasure to talk to you. Thank you very much for having me.